Chair at this time calls Jeremy Newman, Policy Director for the Texas Homeschool Coalition, testifying in favor of House Bill 3316.
Chairman, members, my name is Jeremy Newman, Policy Director with the Texas Homeschool Coalition, speaking in favor of the bill. A lot of the language in the bill is language that we actually brought to Representative Frank from our own experiences, and I'll try and target my testimony to a few particular points. The first point related to truancy is something that we have dealt with on the front end, where sometimes when CPS comes to the family, they start trying to make a qualitative assessment. Our experience was in homeschool situations in particular. They start trying to make a qualitative assessment of whether or not the student is being educated as well as they should be, whereas the Education Code specifically provides them the authority to terminate only if there is no education taking place. And so when we started investigating that, this is the statute that we kept coming back to. And the other issue that I would bring up is that, in family law, there's a saying that termination is the death penalty of the family code, because it cannot get worse in the family code than termination of the parent-child relationship. And so it's something that has to be reserved for a situation where the harm that you're trying to avoid is so great that you have to terminate the parent-child relationship. We just decriminalized truancy last session. So under the Education Code, you can be fined for truancy, and under the Family Code, you can have what is the equivalent of the death penalty in the Family Code for the exact same offense. And so for that reason, we think that that section should be struck completely. I'll also address on page 7 of the substitute, it has language in there that prevents the filing of termination against both parents by default. And there's actually some alternate language we're talking with about the Supreme Court to address the exact same issue. But basically, it has become standard practice in a lot of counties for CPS to file for termination against both parents, even when they only have evidence against one parent. And so the obvious argument there is that if the second parent hasn't done anything wrong, they shouldn't be facing a suit for termination. They will even refer to that second parent as the non-offending parent, and that parent will still be facing a suit for termination of the parent-child relationship.
And so let me ask you a question, Mr. Newman. So does the court generally make a finding against that parent?
The practitioners that have spoken before me could answer that better, but what I'll say is that in our experience, the more common outcome is that the non-offending parent loses because of the punishment by process. So sometimes, in fact, it's someone who gets a default judgment. I can give you an example out of Harris County, where basically the father got this list of accusations and he said, I haven't done anything, I'm not going to show up to defend against this. Well, so he got a default judgment against him.
Okay, I understand.
And so I can answer questions on any of the sections in the bill, but the last point that I wanted to specifically address is the CPS deadlines. The only thing that this language in the bill does is enforce what the current statute already tells the courts they have to do, which is to dismiss the case or to finish the case within 12 months or within 18 months if they grant an extension. THSC had a case that we were involved in that just completed earlier this year that went on for 3.5 years and never went to trial. And the reason for that is because in a lot of courts, depending on the county you're talking about, don't pay attention to the deadlines because they know it is not jurisdictional, which means that it's easier when they get close to the deadline, it's easier for CPS a lot of times to just drag the case on, and that's what ends up happening, and the parent has no control over that. These deadlines used to be jurisdictional, and because of a change that was made in the Family Code, there was actually an unintended consequence of making them not jurisdictional. That's what this is addressing. I can answer questions if the committee wants, but I'll leave it there.
Any questions for Mr. Newman? Show Mr. Schofield present. Any questions for Mr. Newman, members? Not hearing him, Mr. Newman. Thank you for your testimony.